Live ಮಾಡಿದ್ದೀವಿ. ಇಲ್ಲ ಇಲ್ಲ ಈಗಲೇ ಮಾಡ್ತಾ ಇದ್ದೀನಿ. ನಾನು ಮಾಡಲ್ಲ. ಬಂದ ಮೇಲೆ ರೆಕಾರ್ಡ್ ಆಗ ಏನು ಮಾಡಿದ್ರು ಆಗಲ್ಲ. Further hearing matters. Sumanagana.
Lord, I appeal Lord for the appellants in one of these. After Lord a very exhaustive and an exhausting hearing, my turn now Lord to make a very brief response to what has been submitted by Mr. Bhagavat and others. I don't propose to take more than 10 or 15 minutes. The Lordship should permit me not to appear.
Yes.
Lord, in my opening submissions, I had covered, my Lord, a lot of ground which I don't want to repeat. I've also filed, my Lord, a synopsis of submissions. Probably if your Lordship should have it placed before you. It's dated the 19th of September 25. It's a 10-page submission which includes, my Lord, the entire submissions to the High Court. My endeavor today, my Lord, I'm not going to read it again, my Lord, it's on your Lordship's file. I have also divided it, my Lord, for convenience into different sections. So
just one observation.
Yes.
Insofar as the promotions that took place in 2015,
Yes.
and the withdrawal of one seniority list,
Yes.
the note of the committee, you can place it in a closed cover for our just for our perusal.
Yes, actually that has been done before the learned single judge also. In fact, your Lordships will find in the papers, there is a memo regarding original records, which is dated 29th October 2024, my Lord. In that, the original files are placed before the Honorable Court. If those files have probably been taken back, but they're all flagged, my Lord. For each item, there are flags A to F. Some file I'm told the High Court official, my Lord, will have the file and he is present in court.
Memo dated 29/10/2024 you take out along with records.
This contains, my Lord, the note sheets, then the extracts of the resolutions from 2010, then the first 2015, and subsequently all of them, my Lord. And also the minutes resolution of the administrative committee and the resolution of the Honorable Full Court. Flag A, my Lord, is reflecting the vacancy position.
Yes.
So in this, my Lord, in serial order, your Lordships will get, my Lord, each item, the resolution of the administrative committee, and then, my Lord, the matter ultimately going before the Honorable Full Court. These are all the 2015 promotion matters.
Yes, yes.
Now, my lord, I was mentioning about the note of submission, simple synopsis of my submissions. I don't propose to read it, my lord, but if your lordships could kindly just take it in your lordship's hands.
Just
It's-
one minute.
Yes.
Synopsis.
So when it is filed, sir?
19/9/25, my lord. It's dated 19th September 2025. This is a short one with about 10 pages.
Yes. Other notice, sir. Date may be changed, but you show the small.
Lord, I can come back to it later, my lord, just to save time if your lordships are not able to locate it.
Not this. Not this. 10 pages.
So 10 pages. I can, my lord, let the court officer find it, not till then I can proceed and then come back to it. My lord. I don't want to read it, but just to show your lordships the outline of it.
Yes.
Not this.
Now, my lord,
Yes.
The main contention is on what is vacancy and what is cadre strength. Lord, much argument has been addressed, my lord, on this issue. There were number of letters, my lord, that were written and exchanged between the Honorable High Court and the government in this behalf. I have, my lord, prepared a compilation of all the notifications. Your lordships would also please peruse them. I think earlier I had shown them, my lord, but that is 8/9/25. It's a memo with 142 pages, which gives your lordships, my lord, a bird's eye view of how the cadre strength is being computed, starting from 2003 onwards.
Yes.
Now, this statement is supported by the actual government orders that have been issued. So one argument is that there should be some separate notification for increasing the cadre strength. That, my lord, I have submitted, and Mr. Rajgopal has also elaborately argued that there is no such requirement, and so long as the government approves a position, then the cadre strength goes up. And consistently, my lord, not now, but for more than 25 years, this has been the practice that has been followed by the High Court. Whenever a strength is increased by means of an addition of a post for specific reasons or for general reasons, it is treated as part of the increase in the cadre strength. So, my lord, this memo will give your lordships the historical perspective of how each and every additional position that is created is treated as part of the cadre strength. Not so the argument that there may be an additional post created and that post might be changed again, it might be withdrawn. All that, my lord, is of no avail. The reason being that there is a post created and there is an honorable judge accompanying, holding that position. A new argument, my lord, which was to my recollection not canvassed in the earlier round before the division bench, is what is now canvassed by Mr. Bhagwat. And his argument is that there are categories of honorable district judges. One is entry level, then it is selection grade, then it is super time scale. Now, my lord, these are not different cadres. They are all district judges only. Because of this accelerated promotion policy that is there as per the order of the Honorable Supreme Court, some monetary benefit is extended to them. So to say that if a judge becomes a selection grade judge, he will go outside the ambit of district judge cadre, Lord, is an argument, my lord, which has no substance or no basis at all, because they all continue. There's one seniority list for everybody. Some will go. In fact, there are litigations, my lord, in some cases where this super time scale was denied to somebody because of a pending disciplinary case. What should happen to that? Like that, it has come. But they're all in the same cadre. So there is no basis whatsoever to argue that you must exclude the super time scale and the selection grade and super time scale to be excluded in computing cadre strength, my lord, there's no reasoning or logic so far as that is concerned. Then, my lord, we have filed, my lord, another memo dated 7/1/26. That also contains the notifications from 2003, and in this we have made a table, my lord, just for the convenience of the court. I'll just show one or two of them. This is the list. I'll just take one or two of them, Lord. If you lordship go to first page, there's a Law Department government order of 15/2/2002. Then by that, one post was created. That was taken into consideration for cadre strength from 1/5/2003. And the relevant notification government order for that is also included in this. And I put the page numbers also, my lord. Page 1 to 30. Then, my lord, a sixth column gives your lordships the establishment of the court for this purpose of this particular case, the Rendupaila Krishna gang. And the last column, my lord, gives your lordships what was approved: creation of one additional post, supporting staff, and in 2021, in the last column, my lord, I've made it clear that this post, which was created in 2002, has been made permanent. So, like that, my lord, for every addition that has happened, I have given, my lord, this details when it was established. So, the corresponding government orders relating to each of these positions is also contained in this note, with the copies of the government order. The last of them, my lord, is at page 8. In 2015, additional registrar inquiries posts were created. There were 2, 4, 2. That means totally 8 positions. These were not there earlier. And these 8 posts have added up to the cadre strength. So, my lord, my submission is that this is enough material before the Honorable Court to now notice that this is not some ad hoc numbers that we have taken. And your lordships have already seen it in the rejoinder that we have filed. Sir rejoinder, my lord. Your lordships have seen it again, my lord. I don't want to repeat. At page 737, we have given, my lord, date-wise as to what was the position, how many were filled, from which stream it was filled, and how many vacancies were there in this field. In fact, the learned judge notices that, but somehow comes to the conclusion, my lord, respectfully submitting erroneously, that the number of people promoted was in excess of the available quota in the stream. For that, my lord, your lordships have seen it already. There is no material so far as that observation is concerned. Now, my lord, many posts were sanctioned, financial sanction was given, and they have been made permanent from time to time. And honorable judges have occupied those positions, and they are all in office. It's not that something was created and it was omitted later on, or strength was reduced. That has not happened. Then I've already submitted not the entry level selection grade super time scale. There is no ground at all to make any such distinction, because the seniority list is one and the same thing. Not so far as the fast track court judges are concerned, this had agitated the mind of this honorable court, my lord, in a writ petition, a copy of which is produced, my lord, in writ appeal 1006 at annexure B. This is a copy of the judgment of the honorable division bench, an appeal filed by the registrar of the High Court. It's available, my lord, at second volume, page 234. In that, my lord, the operative portion of the order makes the position very clear. What it lays down is that if somebody was appointed as a fast track court judge who was there was no position in the district judge cadre on the date on which he or she was appointed, the date of appointment in the cadre of district judge will take effect when there is a vacancy in the cadre. So that is the operative directions that have been issued, and that has been followed. So now, my lord, the effect of the order of the learned single judge is, one, something contrary to what the division bench has ordered will have to now be done. And secondly, my lord, the various the fast track court judges who have appointed, who have served, and most have retired, and they're now in post-retirement phase. If this order of the learned single judge is given effect to, all of them are going to get affected. So we have made a submission, my lord, before the Honorable Court. In two places, we have made this submission for consideration, my lord. First is in the Sir rejoinder that we filed at page 743, which your lordships will find, my lord, in volume number 3. We have specifically stated that relief that has been granted would adversely affect large number of fast track court judges who occupied that position, and their positions will have to be now changed. And if somebody has gone to super time scale, and because of this reworking, he or she will have to come back to some other scale, and there'll have to be a recovery from all of them, which my lord is something which is not possible in the absence of those persons being there. I have also specifically raised this, my lord, in the grounds of appeal in volume 1 at page 38. I have specifically raised this to say that these arguments which seriously affect the position of fast track court judges ought not to have been examined, or no relief could have been granted so far as those persons are concerned who are not before the court, and whatever they have to say, they could have said. Then, my lord, the submission made is that these affected writ petitioners were not heard in the matter before this exercise was undertaken. But factually, that is not correct, because a published list was published, and many of the petitioners, particularly Mr. Pavanesh, my lord, appeared. He gave written representation. There was a personal hearing given also by a committee of 3 honorable judges, that your lordships will see in the record also. After that, my lord, a conclusion is reached. Therefore, the argument that no hearing was given, my lord, is not correct as per the records. Then, my lord, a substantial time has been spent by Mr. Bhagavat on the question of what is a seniority list, and is this a seniority list or a civil list? Now, my lord, to that, my submission is, my lord, he relies upon Rule 11.2 of the Karnataka Judicial Service Recruitment Rules 2004. If your lordships would, my lord, kindly look at that. That is filed, my lord, along with an index by us. I'm sorry, my lord, it is filed by the writ petitioner, that is the respondents before your lordships, on 16/12/25. There's a memo with 16 documents. Most of them are government orders, and in that they've included these rules also. Because my learned friend particularly refers to this rule 11.2 in his written submissions also. So I would request your lordships to permit me to read that rule, my lord. I'm sorry, we are burdening your lordships with more and more compilations, memos, and list of authorities. It's quite a difficult task to marshal all this, my lord. We understand it.
Rules.
Yes, my lord. In this, the rule that my learned friend has referred to, your lordships will get it, my lord, in this compilation. It begins at page 16, my lord, 16. Your lordship has it, my lord. Page 16. It's the Law Secretariat notification, 9th September 2005. The Karnataka Judicial Service Recruitment Rules of 2004. Now, my lord, please turn to page 18, 18. And kindly peruse rule number 11, which is right at the bottom of that page. Lord, to appreciate this, your lordships may have to kindly ask the court officer to place before your lordships the Karnataka Civil Service rules, because these rules refer to certain provisions of the Karnataka Civil Service Rules. It is Karnataka Civil Services General Recruitment Rules, 1977.
Yes, yes.
Now I'll now read, my lord, Rule 11 at page 18. Application of other rules. Subject to Article 233, 234, 235 of the Constitution, provisions of Rules 5, 6, 2, 6, 3, 8, 9, 10 to 13 of the Karnataka Civil Services General Recruitment Rules 1977 shall, in so far as they are not inconsistent with these rules, mutatis mutandis apply to recruitment of district judges, civil judges senior division, and civil judges junior division under these rules. Now, Lord, please mark the word used is recruitment, not promotion. So, if there is a promotion from the cadre of civil judge senior division to the position of district judge, whether 11(1) will apply at all is a question. This is not a recruitment. Recruitment is only of the writ petitioners. So, they are challenging the promotion of civil judges by invoking this provision. But I will show to your lordships that none of these rules which they are referring to here have anything to do with the promotion of civil judges senior division to district judges position. I should, that's why, my lord, I requested that those rules may be kept in mind. Now, my lord, the important part is this rule starts with the word subject to Articles 233, 234, 235. I'll make my submissions and what is the meaning of this subject to, my lord. But now, if your lordships would see these rules, Rule 5, it starts with reference to Rule 5 of this recruitment rules, this general recruitment rules. Rule 5, my lord, is only regarding disqualification for appointment. This is the KCS General Recruitment Rules 1977. So, Rule 5 of these rules, which is made applicable to recruitment, regarding eligibility, is not relevant so far as these promotions are concerned.
Page number.
But in the book I have, it is at page 249. I don't know if it's the same edition. This is Karnataka Local Laws, volume 36.
77. 24.
77 rules, 249, not in my book. I'm not sure if it's the same. It's called KCS General Recruitment Rules 1977.
Page 30, that book,
Page.
but correct, page 13, right? Book, what is the book?
Rule 5. Rule 5 is not there.
This is in the KCS General Recruitment Rules 1977.
Index ಯಾರು ರೂಲ್ಸ್ ತಂದಿಟ್ಟಿದ್ರೆ ಲೈಬ್ರರಿ ಹೇಳ್ರಿ ಕೆಲಸಿಲ್ಲ ಅವ್ರಿಗೆಲ್ಲ ಅಲ್ಲಿ
Karnataka Service Manual.
CSRs ಕೊಡ್ರಿ 27 ರೂಲ್ ಇಲ್ಲ ಅದ್ರಲ್ಲಿ ಬಿಡಿ ಸರ್ಟಿಫಿಕೇಟ್ ಅಮೆಂಡ್ಮೆಂಟ್
Not in service, ATS. Okay.
This is the KCS General Recruitment Rules of 1977.
Yes.
Lord, in this, Rule 5
Big book.
refers to disqualification for appointment. So what I'm submitting is the rule 11, which my learned friend refers to and relies upon. Refers to certain rules.
Sir, 1 second.
Yes.
So the recruitment rules, rule number 11, is making two categories there, Milo. This is the judicial service recruitment rules. First category is 11.1, which is at page 18. In that category, they're referring to certain rules of the general recruitment will apply. Now, the submission I'm making is none of these rules referred to in 11.1 will have any application to the promotion of an officer from the level of district judge, from level of senior division to district judge. Lord, if it will assist your lordships, one of us can, my lord, place that those rules separately, my lord, so that your lordships will not have to wade through different books.
Yes.
So this first part, 11.1, none of these rules have anything to do with this. Then let's go to 11.2, my lord.
Yes.
11.2, my lord, provides all rules regulating the conditions of service of the members of the state civil services made from time to time under any law or the proviso to Article 309 of the Constitution of India shall, subject to Articles 233, 234, 235, be applicable to civil judge junior division, civil judge senior division, and district judges recruited and appointed under these rules. So, this rule is made subject to articles. 3 articles are referred to. Other than this, there is no other provision. Now, my lord, how to interpret these rules and the applicability? Yes. I have filed a compilation of a list of authorities on 28th of June 23. I'll read only a few lines in one of them. I've already cited it, but on this subject, my lord, how the division bench has understood what happened in that case, my lord, was that there was a recruitment for civil judge senior division, and a draft set of rules had been published, and it had been finally notified. Now, the argument was that this draft was not published in the manner required by the civil service rules. And that has been dealt with by the Honorable Division Bench. And if your lordships have found it, it is 28/6/23. The Division Bench judgment in C.V. Chitra versus State of Karnataka. It's reported, my lord.
Yes.
In that, my lord, the judgment begins at page 14, CV Chitra versus State of Karnataka. And my lord, please go to page 25, ink page 25, which is paragraph number 16, 16. The view expressed by the apex court in Bal Mukund Shah's case, as referred to herein above, fully and completely answers the contentions raised by the learned counsel for petitioners regarding violation of provisions contained in section 3(2)(a), read with section 8 of the Karnataka State Civil Services Act of 1978, section 23 of the General Clauses Act, and article 309 of the Constitution. Next sentence is the finding. None of these provisions can control the recruitment and power of the competent authority, namely the governor of the state, to make rules in consultation with the High Court regulating the recruitment to the post of Civil Judge Junior Division. Therefore, in the absence of any requirement under Article 234 of the Constitution requiring previous publication of the rules, such requirement cannot be read in by resorting to several legislative enactments. As the publication of the draft rules itself was not necessary, the alleged defects pointed out in the publication of the draft rules and in the omission to specify the date on or after which draft rules will be taken into consideration will not vitiate the impugned rules framed by the governor of the state. So the argument was that the general law required the notification draft to be published in a particular way, giving certain dates. That was not done. Therefore, the recruitment is illegal, was the argument. Honorable Division Bench, my lord, after considering Bal Mukund Shah, my lord, is a leading judgment which lays down, my lord, that the high courts are vested with absolute power in the matter of appointment of judges. And government or no other authority can interfere with that, unless by law made. So, my lord, this I commend, my lord, this conclusion for your lordship kind acceptance on the ground that the seniority list about which so much has been spoken is not in conformity with the civil service rules, is not an argument, my lord, which will apply in so far as appointment of district judiciary is concerned. Article 233 and 234, my lord, constitute a complete code, and no other rules will apply to them unless by a rule made with the approval of the High Court, certain provisions are made applicable, just like what your lordship saw, my lord, in 11(1). The rule itself says that so far as recruitment is concerned, the following rules will apply. One objection, my lord, is that you must be a citizen of India or Nepal. Like, these are basic requirements. So when they wanted it to be restricted or made applicable, it was made applicable, but there is no such provision so far as seniority lists are concerned. Then, my lord, the writ appeals filed by the promotees, I'm not holding any brief for them, but they are before the court. They are affected by the order, and therefore, my lord, they have every right to, my lord, point out why they should not be affected by any such finding of the learned single judge. Not in just now shown, my lord, Chitra's case also, insofar as this is concerned. My lord, to the best of my knowledge, my lord, these are the submissions which are put against us, and this is all my submission is, my lord. If there's anything else that Honorable Court would like me to address, my lord, and in your lordship.
Just one observation.
Yes,
the Apex Court had directed that you have the roster point way back.
yeah.
In between, in all the litigations, there's no whisper to the direction of the Apex Court, nor was it made a part of the rules. Any observation on that?
It is true, my lord, that when the Apex Court says that you must do something, you must prepare a rule, if that should be done, there's no doubt about it. But if it is not done, Lord, can somebody who was not in the judiciary at that point of time, can he come forward to the court now and say 2 years prior to my appointment as a district judge, something done was wrong? Lord, this will lead to, my lord, if I can use the expression, a great deal of confusion, my lord. It will all,
No, insofar as the inter partes adjudication,
yes,
of course, that we look at it differently, whether he could reopen that question, etc. But insofar as the High Court itself, when there's a direction of the Apex Court, in none of the judgments thereafter, there is a whisper to that direction of the Apex Court.
I,
Now, perhaps Apex Court wanted some uniformity and had made some observation. So
yes,
now, obviously, we can't enter into it at this point. That's a point well taken. Now, what has happened is happened. There's no question of redoing it. But what would happen is, if at all at any point we are asked to go back, this is not possible simply because it was not adopted. So that was only one thing that was running in our mind, that it was not implemented.
true.
There it rests. We have nothing more to
Yes.
observe on.
My lord, I'm part of the rule committee also, my lord, and I see many times, my lord, the issues which come up before rule committee, my lord, are something of very great urgency now. And this procedural rules, commercial court rules like these, my lord. But sometimes, my lord, I respectfully bow down, my lord, that this ought to have been done. And your lordship's observations in this judgment, my lord, will prompt the High Court, my lord, to take action on that and implement it, my lord, for the future reference.
Yes, yes.
That's all. Great. Sorry, my lord, I could not appear in person, my lord.
No, that's
So I will take about 10 to 15 minutes. Numbers on one vehement submission has been about the vacancies and cadre strength. Numbers, I have filed my written synopsis where at page 33 I have under item number 9 I have said when the cadre strength is post based and if the cadre strength notifications produced by the High Court are gone by, what would be the vacancy position on each of the dates on which we were promoted? And I have also filed a memo on 9/1/2026 as to how the allocation of vacancies has been arrived at. Unfortunately, the pleadings and arguments with direct recruit has been ignoring the rule. They apply vacancy-based quota. It is not vacancy-based quota. The rules are very clear. It is cadre strength-based quota right from 1962. Therefore, my lord, sir, and it is for the petitioners to have placed before the court, applying the quota rule in terms of the recruitment rules and demonstrate before this court that promotees are in excess. No such pleading or no such exercise is forthcoming. Therefore, my lords, my respectful submission is there is not much for this court to investigate because petitioners themselves have not placed before this court what would be the vacancy position if cadre strength linked to the total number of posts is taken as the basis as it should be. Then, my lords, I would like to point out that this is a case where even according to the petitioner's pleadings before the administrative committee, before they filed the writ petition,
16.
the excess recruitment is from LDCE quota. I'll point out that. And we have also placed on record along with an interlocutory application, we have pleaded so in our writ appeal that the difference between what they are now what they are pleaded before the administrative committee and what the High Court has furnished to us is, according to the information given to us under RTI Act by the High Court, there were still 4 vacancies available for promotees. According to the direct recruits, in their representation before the administrative committee, promotees are the the difference is -4, and they also say 25 LDCs are in excess. But I'll just take my lords through the pleading, my lords, that is at, if my lords would kindly take the annexure F in the writ appeal filed by the High Court, because that is the paper book we have been referring to. Annexure F, my lords, is at page 437.
ಸುಮ್ಮನೆ ಗೊಳಿಸ್ತಾ ಇರೋದ ನೋಡಿ.
Annexure F is, my lords, it commences at page 422 in volume 2. Relevant part, my lords, is at, could my lords get volume 2 of the High Court writ appeal paper?
Yes, yes.
422 is the representation they make on 11/8/2016.
16.
11/8/2016.
Yes.
In that, my lords, at page 437, it is a subpara 10 of para 8, which commences at page 427. They will give a tabular column. What, according to them, was the position in accordance with the earlier judgment of the division bench. Under 65% promotion quota, 53 posts. Under 10% competitive examination quota, excess 25 posts. Under 25% direct recruitment quota, 16 posts. This position becomes relevant. Thereafter, my lords, at page 456, their stand is, even otherwise, though the promotees are entitled only to 86 vacancies out of 138, towards quotas 115 persons are accommodated. In this 115, if my lords deduct what they say as excess 25 posts for LDCE at page 438.
No, but the premise itself is only on the what they call as increase in cadre strength.
Yes,
Now,
madam.
if you say it's post based.
No, I am not saying
No,
what.
I'm saying correct. So I'm saying developing from now, if we were to take that, it becomes again vacancy based.
I am not going by that. What I am saying is, I am relying not that this is the correct position. What I am submitting is how their stance has been changing from day to day. I am not saying for a moment that what they are saying is the correct position in law. On facts, what they are saying is, at page 438, they say LDCE promotees are 25 in excess.
Yes.
And what they are saying in Annexure G commencing at page 442, at page 456, para 3.9, they say 86 vacancies as against which 115 persons promotees are accommodated. 138 minus 86, if it is taken, it comes to 115 have been 115 minus 86. If it is taken, it comes to 29. Of that 29, if we exclude 25 LDCs, because LDCs also are treated as promotees throughout by them, according to them, their representation, annexure F and G read together, excess promotees will be 4.
This mathematics is,
Well, I'm because my lords,
we can't enter into that kind of a logic.
no, I'm saying, but I am submitting my lords. It is a triviality they are arguing. Before the administrative committee, in 2 representations, they make 2 different figures. Then High Court gives me under Right to Information Act certain informations, according to which on the date even the second batch of promotees who are respondents, who are appellants here, is taken into account. There were still 4 vacancies available for the promotees. May I take, my lords, to that document, that is, my lords, in IA number 3, which is at page 672 of the paper book.
Next volume. Last volume.
$672 1162. Take the 1162. It is 672 is in the companion, the second volume. 672 is the, yes.
Annexure PL.
That is not IA number. It is not in the High Court writ appeal. It is in the companion writ appeal. IA number 3. It is at page 657. IA commences in the second volume of the companion writ appeal.
Not at this.
Because this IA is there only in this appeal and not in the other appeal.
Cover the item. Equal. 6-7.
Writ appeal 1162. ಅದರಲ್ಲಿ 2 ಇದೆಯಲ್ಲ correct. There also there are 2 writ appeals.
1162. 672.
IA. 672.
One 1162.
616.
1162 ನಲ್ಲಿ page 657 start.
657.
3 of 23.
Yes, Manus. For under order 41, rule 27, read with 151 for production of additional documents in the writ appeal. In that, if my lords would kindly turn to page 672. That is the information given to one of the appellants by the High Court by its letter dated 10th August 2023. That letter is at 672. If my lords could turn to page 673. Paragraph 3 there, kindly refer to date 21/8/2015. The vacancies that were available after our promotions is stated as 4 vacancies for promotees still to be filled up, -2 LDC. LDC are in excess, 50 DR shortage. Therefore, both the promotees and DRs are within their quota. If they are within their quota, they would get their seniority from the date of direct recruitment and from the date of promotion, respectively. That is what has been done in the impugned seniority list. And assuming -4 and +4 are correct, even then, it would not take the DRs above the promotees. Therefore, the entire argument that is being advanced is on a triviality. And settled doctrine is that courts would not concern themselves with trivialities. Doctrine of de minimis would apply. And I have already set out in detail, even after axing 32 posts as found by one of the judges in the division bench, even then the seniority position would not undergo a change if quota is calculated on the cadre strength. Therefore, the entire exercise of having one single judge, then one division bench and one full bench, these are all uncalled for in a case of this nature, is my respectful submission. And for that proposition, I would just invite my lord's attention to one judgment of the Supreme Court, which went to Supreme Court only from this court. That is, my lord's Indian Banks Association versus Devkala
We
Consulting.
are giving back. Again.
Huh?
We are giving the case.
ಏನು?
We are giving the case.
Re-arguing Allah. Only I said, in fact, I had said that it would not make any change. I had also said that even if 32 is axed, only new point I am saying is it is hit by de minimis. Until except that phrase, everything else I had told. Paragraphs 29, 30, 31 of Devkala Consultancy may be seen. In that para 30 only, what is de minimis? Para 31, they refuse to apply it to that case on the ground that excess collections have been made from 5 crores borrowers. Otherwise, de minimis as a principle, Supreme Court admits at para 30. At 31, it refuses to apply on the ground that this is not a de minimis. The amount collected is not negligible. Because in that case, actually, it was about 15,000 crores, which ultimately was directed to be kept in a trust. Banks were to calculate and because this court had directed amount to be refunded to the borrowers. Then 5 crore borrowers to get them and then to spend the amount. Then the Supreme Court directed you make a trust in favor of the persons with disabilities and contribute the fund to the trust, and trust be managed by a body suggested by the Supreme Court. So this is a case where, in fact, I had also told in my decision, except bringing Devkala consultancy, rest all I have said. Then another argument that has been placed by relying on two judgments, my lords, Uttarachand Forest Rangers Association and Yoganand HC. These are the two judgments relied on by my learned friend Bhagwat. I am only replying to those judgments. First, Uttaranchal Forest Rangers Association, what it said at para 30 of the report. Same judgments don't give two copies. I can already papers are so different. Quantum of papers is frightening. Uttaranchal Forest Rangers Association, judgment 2006 10 SCC 346. 11th March ನೀವೇ ಕೊಟ್ಟಿದ್ದು ಸರ್ ಅಥವಾ ನಿಮ್ಮ ಕಂಪ್ಯಾನಿಯನ್ ಅಡ್ವೊಕೇಟ್ ಕೊಟ್ಟರು? ಅವ್ರು ಕೊಟ್ಟಿರ್ಬೇಕು. ಕಂಪ್ಯಾನಿಯನ್ it is I think Mr. Agarwal gave this because my instructing counsel has noted on this 11/3/2026.
That is not
This Mr. Agarwal has relied on. I don't think you will not disown Agarwal in any case. If you disown, I will be happy. He relied on para 30 at page 359. Last line there, Manoj, at page 359, and first 3 lines in page 360. It is well settled that promotion in excess of quota makes an employee an ad hoc employee, and seniority cannot be given to such employees on the basis of ad hoc promotion. Two conditions have to be satisfied. They have to plead and prove that I am in excess of the quota, which I pointed out. A rickety pleading based on a wrong perception of the rule is there, and no pleading based on post-based quota, no data based on post-based quota. Therefore, this would be inapplicable. Another judgment for the same proposition that they relied upon is Yoganand HG. This also on 11/3. They relied on paragraph 8, Milos. From the aforesaid judgment, it is clear that when the statute provides for filling up of vacancies by promotion as well as by direct recruitment on 50-50 ratio, the vacancies, this is again linked to vacancy based quota, have to be filled up strictly according to the rules. It is settled that prescription of quota for different posts is constitutionally valid. If promotions are made to vacancies in excess of the promotional quota, promotions may not be totally illegal, but would be irregular. Promotees cannot claim any right to hold the promotional post unless vacancies fall within their. There is nothing more than what has been said by earlier division bench in Registrar General's case. And here again, this reliance must meet the same fate as Uttaranchal Forest because of the. No, it's about creation of posts. Both Mr. Bhagwat and Mr. Agarwal emphasized that it is the prerogative of the government. Mr. Naganand has answered it. I cannot improve it, except referring to again Karnataka State Civil Courts Act, which I said notification of cadre strength of senior civil judges and civil judges is mandated, but not of the district judges. Therefore, my lords, their reliance, again, this is also, I think, led by Mr. Agarwal, that is Union of India versus Ilmo Devi, 2021, 20 SCC. In this, what had happened was certain ad hoc employees had approached the court for regularization. High Court had directed create supernumerary or vacancies and accommodate them and regularize them. In that context, Supreme Court said that para 13 of this judgment, para 13, last 4 lines of para 13. Even the creation and or sanction of the post is also sole prerogative of the government, and the High Court, in exercise of the power under Article 226 of the Constitution, cannot issue mandamus and or direct to create the sanction. Only requirement, one thing, my lord, it is the government which creates the post, but when it comes to district judges, in consultation with the High Court. We have already gone through that procedure where I have explained that High Court recommends to the state government to have an additional court or agreeing with the proposal of the state government to have an additional court or at different locations. Then state government issues the notification establishing the court. Even if it's some additional court, state government issues the notification. That itself is the notification of creating the post. And this is in tune line with the view expressed by the senior judge in the division bench, relying on judgment of the division bench of the High Court. Then, my lords, Mr. Bhagwat also canvassed this, that is, and that has found favor with one of the judges in the division bench. Temporary posts are to be excluded. Then extensively, KCSR has been quoted to say what is a permanent post, what is a temporary post, what is a quasi-permanent post. Several, what I would just say that verbal exercises have happened. Answer to all these is found in judgment of the Supreme Court in P.S. Mahal.
Yes.
P.S. Mahal. It is a judgment rendered by 2-judge bench, but this has been approved by Constitution bench in Direct Recruit Class 2. There they approved P.S. Mahal as also V.V. Badami.
MOTs are post. Direct recruitment is not meant for.
No, I am not on that proposition. I am on a different proposition.
Direct recruitment.
No, I am welcome.
Please.
Para 21, 22 of the health in. Para 21. Last, that is, my lords, at page 1312, last 4 lines on the left-hand column. In the first Bishan Swarup Gupta's case, a vacancy which is not for a few days or a few months or otherwise adventitious, that is, my lords, so long as the vacancy is permanent vacancy, that is to say, in the words of Palekar J, in the first Bishan Swarup Gupta's case, a vacancy which is not for a few days or a few months or otherwise adventitious, for the purposes of operation of quota rule, A vacancy will have to be treated as a permanent vacancy if it is not for a few days or a few months or otherwise advantageous. Vishnu Sarup Gupta already I have relied on in my submission. Then, my lords, we have in the words of Palakarje adopted wholly and completely in A.K. Subbaraman's case a negative definition of what may be regarded as a permanent vacancy for the purpose of application of the quota rule, and it clearly shows that a vacancy which is of a short duration arising on account of fortuitous or advantageous circumstance would not be regarded as permanent vacancy, and in such case by reason of the very nature of the vacancy there will be no question of making recruitment to the cadre as to attract the applicability of the quota rule. It is therefore obvious that if a vacancy arises on account of incumbent going on leave or from training or on deputation for a short period, it would be a fortuitous or advantageous vacancy, and the quota rule would not be attracted in such a case. But where a vacancy arises on account of incumbent going on deputation for a reasonably long period, and there is no reasonable likelihood of the person promoted to fill such vacancy having to revert, the vacancy would be subject to the quota rule because it would be a regular vacancy in the post of executive engineer, and the person promoted to fill the vacancy would be an officiating executive engineer who would continue as such without reversion until confirmed, and his promotion would therefore be by way of recruitment to the cadre of executive engineers. Of course, it should be made clear that vacancy which attracts the applicable quota rule is the vacancy in the post included in the sanction strength for the cadre and not vacancy in the deputation. There may be a vacancy in deputation post in another department or organization. Engineer holding the post is included may be sent to such deputation post, but the vacancy which would call for the quota rule in such case would be the vacancy arising in the post of executive engineer within the cadre by reason of the incumbent of that post going to the deputation post, and not the vacancy in the deputation post which would be filled in the district. Therefore, and then, my lords, at page 1314, that is at the end of para 22, right hand column, conclusion, it is thus clear that the vacancies in the posts of executive engineers arising on account of deputation of executives to other departments, organizations and public undertakings for a period of 1 or more years were long-term vacancies, and they could not be regarded as fortuitous or advantageous in character, and hence they were subject to the quota rule. This answers two arguments advanced by the other side. One is temporary vacancies. Therefore, they are not subject to quota rule. Second is deputation vacancies when they exist in some other organization cannot be counted for operation of the quota here. That is how they said Lokayukta, all those things, and they made one more point that when more than one method of recruitment is provided. But the fact remains that High Court has sent on deputation. The moment people are sent on deputation, it would be a vacancy arising in the parent cadre here, which has to be filled up in accordance with the quota. P.S. Mahal is a complete answer to their argument on deputation post, temporary post, and all that. This is general declaration of law made in P.S. Mahal. And it is nobody's case that any of the posts to which we were promoted was of less than 1 year duration. Yes, Telegi trial is over, but did it take less than 12 months? Therefore, my lords, to say that these are temporary vacancies, I exclude, and no regular promotion can be made on that. That would be plainly contrary to the dictum laid down by the Supreme Court in P.S. Mahal is my respectful submission. Then, my lords, of course, Mr. Naganand also has answered this contention that is regarding the upgradation. One respectful submission I would like to make is right from the year 1980 onwards. Earlier seniority lists I have not been able to see. And civil lists, of course, of every year I have gone through. All these include super time scale district judges, senior scale district judges, and also the entry level district judges in the same column, that is district judges. It is not a creation of a separate cadre. They are part of the same cadre, but with different pay scales. You may lords take a look at 2004 recruitment rule. The misconception about upgradation, taking them into a different cadre, would vanish. Kindly see, my lords, 2004 recruitment rules. That is, 2004 recruitment rule, my lords, is at page 704 of the High Court's writ appeal, volume 3. At 705, the 2004 recruitment rule commences. 705 is the entry regarding district judge. There is only one cadre of district judges. No senior grade, no super time scale. A single cadre, because 83 rules contain something somewhat differently.
We are holding the book. 2004 rule is
2004 rule alli, there is only one cadre, that cadre of district judges. There are no two cadres or there are no three cadres. Yes, 1983 rules said, that is at page 691. ಎರಡು cadre ತೋರಿಸಿದ್ರು. One is, sorry, two cadres were shown. Sorry, ma'am, I'm extremely sorry. But ma'am should be understanding Kannada by now. Item number 1 at page 691 is district judges super time scale. 2 is district judges. And some cadre strength notifications also had been issued, showing the two separately. That is at page 702. That was in the year 2001. District and session judges super time scale 20 posts. District judges 46. But with the advent of 2004 rules, there is only one cadre of district judges in the state. And this is rightly so, because Supreme Court also has taken note of this position even in the year 2023. I will take my lords to that a little later. Before that, in 2016 itself, a division bench of our honorable court, that is, my lords, in Union of India versus Ashwathanarayan Rao, Ashwath Narayana KL, unreported. Then same, then same judgment. More copy kodi cyber guide kodi. My lords, may try to take para 16 at page 23. Para 16 commences, my lords, like this. It is worth to refer.
Yes.
It is worth to refer as an illustration the financial upgradation given in Judicial Department in the name and style of Assured Career Progression Scheme. Under the said scheme, pay scale for civil judges of junior division, senior division, and district judges with regard to financial upgradation was introduced as per the recommendation of the First National Judicial Pay Commission. Recommendations. As per this recommendation, the following financial upgradations were given by the government by its notification dated 9/9/2005. Civil Judge Junior Division, Civil Judge Senior Division, then 3 Civil District Judges. That I'll read in detail. So far as the district judges are concerned, 25% of the cadre strength of the district judges, it is within the cadre. 25% of the cadre strength who have completed not less than 5 years of continuous service in the cadre of district judge, they are entitled for selection grade scale of so much. 2. 10% of the cadre strength of district judges are entitled for super time scale of so much, and they are to be selected on merit on seniority basis. The said assured career progression scale given to 3 cadres, civil judge junior division, civil judge senior division, district judges, clearly indicates that there is no question of promotion to the next cadre, but it is only the financial upgradation in order to avoid frustration in the same cadre. Therefore, my lords, it is futile to contend there are 3 cadres, 25% you cut off, 10% you cut off, what remains is only 35% or 65%. That's all contrary to law. Then, my lords, there is yet another judgment of Lordship Justice Ravindran, that is, of course, in Supreme Court. Bharat Sanchar Nigam Limited and R. Santakumari Veluswamy. 2011. Nine SCC 510. The entire discussion in this petition, in this judgment is, what is the difference between upgradation and promotion? Whether they are one and the same. Because if it is promotion, reservation would apply. If it is upgradation, reservation would not apply. But I would not trouble my lords with the entire. Kindly turn to para 29 at page 524. On a careful analysis of the principles relating to promotion and upgradation in the light of the aforesaid decisions, the following principles emerge. 1. Promotion is an advancement in rank or grade or both and is a step towards advancement to a higher position, grade or honor and dignity. Though in the traditional sense, promotion refers to advancement into a higher post, in its wider sense, promotion may include an advancement to a higher pay scale without moving to a different post. But the mere fact that both, that is advancement to a higher position and advancement to a higher pay scale, are described by common term as promotion, it does not mean that they are the same. The two types of promotion are distinct and have different connotations and consequences. 2. Upgradation merely refers to merely confers a financial benefit by raising the scale of pay of the post without there being movement from a lower position to a higher position. In upgradation, the candidate continues to hold the same post without any change in the duties and responsibilities, but merely gets a higher pay scale. Therefore, when there is an advancement to a higher pay scale without change of post, it may be referred to as an upgradation or promotion to a higher pay scale. But still there is a difference between the two. Rest of it is, it can be different. All these, my lords, have now found a place in the very recommendations of the Judicial Pay Commission. That is what is considered by the Supreme Court in All India Judges Association, AR 2023 SC 2673. In this judgment, my lords may take page 2695. After para 73, item 11, it is titled para 73 minutes, 2695, right hand column.
Yes.
Changes in percentage of district judges selection grade, district judges super time scale, recommendation 44.16. The commission has recommended, could my lords get the page numbers? The commission has recommended the increase of percentage of district judges who will be entitled to district judge, yes, my lords, para 74.
Bottom, there is a page number.
Yes, man. I am referring to page number at the top, 2695. ಇಲ್ಲಿ ರೈಟ್ ಹ್ಯಾಂಡ್ ಕಾಲಮ್ ಅಲ್ಲಿ ಬೇರೆ ತರ ಕೊಟ್ಟಿದ್ದಾರೆ.
Sorry to interrupt you.
Sorry, my lords.
I have produced the very GO recommending the very case what government passed. Kindly take my.
Very sorry, my lords.
enactment. The very judgment is referred. Plot in the High Court plot.
ಬೇರೆ ಕೊಟ್ಟಿದ್ದಾರೆ.
DPR pass executive order. Kindly take.
Sorry, my lords. Page numbers, there is some difference. I have true print with me. He has new. Print is true. What has been given as print to the court is print is true, but it is not true print. That is, my lords, it would be
Page number 25.
at the bottom of the page number would be, my lords, 25 in the copies my lords have. 11, changes in percentage of district judges selection grade and district judges super time scale, recommendation 44.16. The commission has recommended the increase of percentage of district judges will be entitled to district judges selection grade, district judge super time scale. The reasoning of the commission is that due to the limited percentage of district judges super time scale and district judge selection grade, many judges from larger states are unable to reach higher posts before retirement, even though they have spent considerable time in the district judge cadre. It is also found that as of October 2019, only 1,515 judges out of the cadre strength of 7,382 district judges were getting the benefit of selection grade and super time scale. Here also they proceed on the basis district judges is a single cadre. The benefit of super time scale and selection grade not reaching a majority of the district judges prior to their retirement is a situation that should be avoided. The recommendation of the Commission that selection grade and super time scale posts should be increased by 10% and 5% respectively merits acceptance. Essentially, this would entail that the district judges at the entry level shall be 50%, selection grade 35%, and super time scale 15% of the total cadre strength of district judges. The recommendation 44.162 and 3 are regarding the upgradation to be given to the issue by applying the principle of seniority cum merit, and further that if the post remains or continues for 3 years, it shall form part of cadre strength. These recommendations of SNJP may be considered at the appropriate stage as they do not have a bearing on the issue of pay. Only thing they left out is whether a post beyond 3 years should be made a permanent post. Then let us kindly see at para 83 tabular column. There is a sum up. What are the recommendations accepted? What are the recommendations deferred? 44.161 that I am not able to tell the page number, 44 in the same tabular statement. That is when it's at the last line of page 30 of that judgment. The post of district judges selection grade shall be increased to 35% of the cadre strength as against the existing 25%. The district judges super time scale shall be increased to 15% of the cadre strength as against the existing 10%. It will be effective from 1/1/2020. Accepted. Next line. The upgradation benefit shall be given to the district judges by applying principles of seniority cum merit instead of merit cum seniority to be considered at the relevant stage. Next also to be considered at the relevant stage. Therefore, it is one thing that is clear is this assured career progression came on the basis of the recommendations of the first National Pay Commission or second National Pay Commission. And after they are implemented, 2004 recruitment rule has abolished the concept of super time scale or senior time scale being a separate cadre, and that is the position even today. Therefore, it is not correct to contend that there are 3 scales of pay, therefore there are 3 different cadres, and in a very seniority list, even in the seniority list impugned, all of them are in the same seniority list. Only thing is those who are super time scale, they will be unblocked senior to the next persons. Therefore, my resolution submission is no case is that's all I would like to submit, my lords, and I'm grateful to my lords.
I have one clarification. There is a definition of promotion. So, but I will not take more than 15 minutes. Not according to me. I think I will not take. I will not take more than what? I'm extremely grateful. I will not take a lot. Next days.
A reply, I don't know, my lord, when it will end.
They have argued the new point. Otherwise, I would have not made. That's all. Lord, promotion is defined. What is promotion? Promotion means maybe higher post or grade. In the present case law, the FS code legislative law in 2002, Lord, I kindly take the enactment and list of produced by me for a moment. Rules, there is no concept of the three cadres at all. I agree. But the question is, FX code legislative law in 2002 itself. Kindly appreciate this. Accepting not 25% of the district entry level. It is a post of entry level. It is a post, next post is selection grade. Next post is superintendent. Kindly appreciate this. Though 2002 judgment not legislated law, in 2006 they not passed it. Kindly take for a moment page 38 when it was passed. Page 38 of the law. List of
What the rule is that made a list and mark notifications. KCS I could rules 2004.
Not got it. And this enactment by law 16/12/25.
Yes, sir.
Lord kindly see when it was passed 22/4/2006. When it will come into effect? Not 1793. But kindly appreciate this, Lord. 25 is the cadre strength to district judge. Is the regard for Lord seniority, merit cum seniority, base care is entirely different. In the same way, Lord, 10% cadre strength district judges of selection grade, Lord, is seniority, merit cum seniority, for important scale. But 2004 rule is that was not there at all. Even though FX code is the law. Therefore, if it is not there in 2000, have they not implemented this GO? Let them say High Court never said so. High Court admitted this has been implemented. They are nothing said about it. No, Lord.
See this. There is a preamble another day I showed a number. Very extract of this report. Yes.
There is no separate seniority list. I will come that lot. Rule 10 itself says so. But kindly come to general recruitment rules definition of promotion. What is a promotion? Lord? Change of scale also amounts to promotion. And see, this court never interpreted that. What is promotion? General recruitment rules, Lord, rule 2M defines what is promotion. Promotion means the appointment of a government servant from a post to grade of service or class of service or to higher post, higher grade of service or higher class of service. But it defines everything. It may be change of scale about to post also promotion. But non-preparation of merely we have prepared from time to come. But it is not the reason to hold it. Why? Because Rule 10 is there right from 1957 of Karnataka government seniority rules, which defines how to prepare a basic seniority list. And it, for a moment, kindly take Rule 10 of the Karnataka government seniority rules.
Cases are similar. Cases. There are promotion rules. The Karnataka civil servants promotion rules. Index
What does it say? But I showed you lecture A and N both to show that there is not a seniority list at all. What it says, what mandates of the law, which division bench accepted because Rule 11(2) says all rules framed under any other law or rule under 309 is applicable to district judge cadre. 11(1) is recruitment, 11(2) is all appointment to district judge. Appointment to district judge is through three modes. One is promotion, 65%, 10% by committee to examination, 20% recruitment. 11(2) applies what? Division bench categorically has given a finding. Karnataka government seniority rules will be applicable. The district judge cadre. Annexure B, page para 67, particularly gives an answer referring to Rule 2 seniority, Karnataka government seniority rules. Kindly take for a 10 minute, Rule 10 of the seniority rules, what does it mandates? There shall be prepared every year for each cadre of service or class of post, kindly note it. Each cadre, merely they did not prepare in upon Rule 10. We have prepared one district judge cadre. Would it suffice the Rule 10 of the Karnataka government seniority rules? And there are three cadres existed, legislated by the Apex Code in 2002 itself, not now. 2002 judgment is implemented in 2006. Kindly appreciate this. 2002 also, my lord will remember, 40-point roster of Upgradation would apply. Para 34. Till today it is not implemented. But now, however, 1911-25, Supreme Court changes the law. 4-point roster would apply as far as the district judges are concerned. Till 1911-25, what will happen? It is law declared by the Apex Court. Now, Rule 10 says, this. There shall be prepared every year for each cadre, kindly note it, each cadre of service or class of posts, kindly note it, class of post. Class of post, a seniority which consists of names of all officers on the set cadre, class of post arranged in the order of seniority in accordance with this rules, seniority shall be prepared by concerned authority. So Rule 10 mandates every seniority of every cadre post shall be prepared separately. High Court now, according to we cannot justify say, no, all years to come we have prepared one list. That is sufficient. No. My lord is laying down the law at least for future purpose. When Apex Court, they said 2002 itself, there are three grades of district judge. Entry level, selection grade, and the superintendent. Question now is, I showed you a lordship. High Court has produced the cadre strength notification. They say principal district judge is also part of the cadre strength district judges. Would it? But I showed you a lordship that day in the notification 9/10/25. Not only deputation in 3 modes, they did not whisper about it, how it would be included. But they say in the notification principal district judge also will include entry level. That is sufficient. Kindly for a moment, take the High Court notification dated 9/10/25. All notifications they have produced before this court. but which includes the post of page 73.
You have shown that.
I showed that day, I will not again explain.
Principal district judges.
Yes, Lord.
You have shown that another.
Could it be included in the cadre strength of district entry level? Can a district entry level can be posted there? No? The analogy of the High Court is accepted. But then, Lord, question before then, Lord, is the constitutional judgment, Lord, as verified as far as the Lord, when the rules are holding the field. 233 holds the field. Right? 230 does not prescribe not quota. It only says appointment. How it should be made? What is the quota? Is concerned what? Again, what rules of 1983, 62, 83, and not 2004. Right? Is promulgated. In constitutional judgment, Lord, a Supreme Court, Lord, in state of Bihar and another versus Lord Bal Mukund's case. Right? Exact question was framed. If the rules are inconsistent with the Lord 233, 234, right? The rules also hold the field. It is not opposed to Article 233. Para 62, 63 question is framed. I already read out to the Lordship. Then, my Lord, the other judgment now cited by my learned friend has absolutely no application. For a moment, my Lord, the decision of Lord in one Bharata Sanchar Nigma, question is entirely different. In the same way, my Lord, division bench, Lord, in Union of India versus Lord judgment. But it's only fact of those cases. This geo can never be interpreted because 24/2/2003 it came into force. Stating the Lord, these are the cadre seniority of merit, they have to pay 25% and no, my Lord, that geo, Lord, which is my understanding that 1925, Lord, kindly take this geo, Lord, which I have produced, Lord, page 41. But I have produced everything to show that I am not that already geo 1923 government order, FX court order is already executed by the in High Court, DPR fast executive order. Kindly take for a moment, not page 41 of the list of enactment.
Actually, you have put cases.
Why not we kindly see the reference number 2? What is the judgment? The same judgment is referred. But there are no right from 2002 till today. Supreme Court only passed interim order. Kindly appreciate this. Right from 2095 onwards, Supreme Court passed interim order. Even 1925 also not interim order. But kindly take for a moment. Interim order whatever FX court did 19/23, which Mulad referred, which I have produced Mulad in my list, volume 2 of the judgment. See that I have already produced. Referring to that Mulad, kindly see the cadre strength. If they say Mulad, cadre strength need not notify according to that Mulad, kindly see that. High Court must appreciate this. At least to bring kindly see further what GO says, Lord. It refers to the very judgment 90/23. Then, Lord, 14.616. Kindly note it. In 19/23, Lord, in table 44.161, accept that recommendation, increasing in what 25% to 35% as election rate is concerned. Got it? In the first serial number in the list 44.16 is the column referred in the FX code in 19/23 judgment. Column 2, the post of district judge selection rate 35% of the strengths, again 25%. Earlier it was 25%, 24 to 2006. Now, my lord, increased to 35%. Again, my lord, 15 to 10 to 15. Super time scale. Kindly come to next, my lord. The cadre time. But they cannot say, I court cannot say, no, cadre strength is concerned, did not fix. Now it is fixed. When it was fixed, my lord? In 24. But in 24, what? Earlier existing cadre strength of selection grade is 93. Should they be included in their lot in the entry level cadre lot? Can you see lot? Existing cadre strength 93 selection grade. But can you see now 35 for existing cadre lot, number of addition to 32. Therefore, cadre strength there must be there. Increase 28%. Shall be excluded in district entry level cadre. Then the lot can you see super time scale, pay scale. But earlier was 37. But what is? Column 3, unnumbered column 3. No, my lord, it is 0.5. Increased to 5. Totally 37. But therefore, my sufficient to your lordship is, my lord, cadre check notification must be there for all cadres. Entry level, district blood, super time scale, and selection grade. According to me, my lord, what law is, I am making my submission. Whether, my lord, one may win, one may, my lord, lose the case. Doesn't matter. It doesn't matter. It makes no difference. Even if they are losing the case, it makes no difference. Let this court law laid in the correct law. Then, my lord, notification not necessary at all. According to them, according to the High Court. But that's not my sufficient to your lordship. There must be cadre check notification for entry level. There must be notification for super time scale. What is the cadre check? As Lord already highlighted, Lord, in the very view, existing cadre was 93 selection grade, 37 super time scale. If this cadre shall be as on Lord 2000 Lord this seniority is concerned, they must notify what it is. Failure to notify the cadre strength, as enumerated KCSR rules,
Entry level is not valid. In that cadre, they should.
High Court corrected it in 24. Till that time, the High Court did not DPR did not notify what is the cadre strength. My lord asked the Lord the additional advocate then that day to produce the cadre strength after 33/2001. There is no notification according to me. Notification is only not page 41 is the as far as cadre strength of a super time scale selection grade is concerned. As on today, it is the cadre strength. As on 2015, when we do not know, they are not notified. My lord has to lay down the law. What is cadre strength means in terms of rule 87, 34, 46 temporary post, permanent post, and then rule 49. When temporary post rule is not created for a particular purpose, if it is ended, but it will be deemed to be abolished. It cannot be included in the cadre strength at all. Rule 49, note 2, which I have explained to you.
This way, the after, so we will have it after then we wind up.
Your Lordship, if I may, appearing on behalf of Senior Advocate Gaurav Adhikar, who also be filing the written arguments.
Sri Council P.S. Rajgopal
SS Nagar.
as well as Sri S.S. Naganand have been concluded. List for reply of other councils, if any, at 3:30 on Wednesday.
No, Mr. Bhagavat, my lord, has probably started re-arguing the case and added some new points. If there's anything I want to say, my lord, can you permit me for a few minutes?
I have given this notification much earlier when I commented.
Which you are not raised at all. These three levels not raised. It's not in the writ petition.
But these notifications are given before commencing the argument. But
Not in the pleadings.
Giving without pleading. Giving ಅಂದ್ರೆ ಕಾಪಿ ಒಪ್ಪಿಟ್ಟು ಅದು
3:30 on 18.